I think the impact is going to be significant, not just in terms of voter ID laws specifically, but in terms of how the court evaluates fundamental right to vote claims. Earlier you had referenced what the Arizona Proposition 200, which has a voter ID component which requires one form of photo identification, two forms of non-photo identification. But in addition to that, another requirement that voters provide proof of citizenship at the time they register to vote. And beyond the voter ID laws, let's say if the court comes down in Indiana's favor, you are likely going to see more states looking to pass laws that require voters to provide documentary proof of citizenship at the time they register to vote. And I think that would actually have a greater impact than the voter ID laws themselves. Again, being counsel in the Georgia case, I'm going to dispute a couple of things that Brad has said about the case. One of the facts that came out in that case, and this was information that was provided by the state of Georgia just prior to the trial, that there are 198,000 registered voters in Georgia based on Georgia's own analysis that don't have a driver's license or what they call a non-operator license in Georgia. So there are going to be people who are going to be affected by these laws, and I think we will see that. I think we will see that in Georgia in 2008 as we go forward.
Deborah?
Yeah, I mean, a lot will depend on precisely the reasoning that we get in the opinion.
Mm-hmm.
If a majority of the court adopts the incredibly cynical attitude toward the right to vote, that it really doesn't make such a difference if you have it or not, and so therefore we don't really need any evidence whatsoever of a real problem here. Just knowing that there is some out there, whether you can document it or not, is enough. Then I think we're going to have huge ramifications far beyond the voter ID, because the fear of fraud, the unproven allegations of fraud, are being used to justify voter suppressive measures of a wide variety across the nation. So we see restrictions on third-party voter registration groups. We see database management policies. We see a lot of other types of measures that will potentially be upheld in the name of protecting fraud. So I do think that dependent upon whether the court's willing to just throw up its hands and not look closely at all at what the state's doing and simply defer to its assertion that there's a problem or there might be a problem, and that even though there's never been a problem and they can't actually find a problem that the voter ID provision actually will address, that's good enough. It could potentially transform, I think, election law in this country.
I want to point out, Jonathan made a point that, for example, in Georgia there's 198,000 people who don't have ID, and so he says there are people, and this is his exact word, who would be affected by this. That's exactly right. People who would be affected by it. Affected, do I need to point out, is not the same as disenfranchised. People are affected by voter registration laws. Is it unconstitutional to have voter registration laws? That prevents some people in this country from voting, and there's no doubt about it. Probably far more people prevented by voter registration laws than prevented by photo ID. Are those laws unconstitutional? And if there's no evidence of impersonation fraud, what state purpose is really served by voter registration? I mean, we need to think about these things and think them on down through the process. Every burden on the right to vote, or on any right, is not of constitutional dimension. And I would be much more impressed by the arguments of the Brennan Center, were they to take that approach that they don't like sort of nebulous burden on something like campaign finance reform, where on the basis of the appearance of corruption, they have vigorously lobbied to suppress the rights of people to free speech in campaigns that are not ephemeral, where there are specifically identifiable people who are prosecuted and pay fines regularly.
We can probably have a debate over the campaign.
Well, I don't want to do it, but I want to point out that there's this sudden reversal in a case that doesn't seem very strong on it. I feel very comfortable in saying that while I'm uncomfortable with the idea of proceeding on the weak evidence the state has, in a sense, there has to be that evidence that something's burdened. So I think the positions can be reconciled, but it's very hard to reconcile the position the Brennan Center takes here with the position they've taken on other voting issues, like campaigns.
Since there's been an ad hominem attack, I think
we'll move on to the question.
There's really a big difference between the justifications that have been offered for the regulation of money in politics and the justification here. And that is that there actually is a lot of documented evidence of corruption as a result of money. There was an ample legislative record that was built, for example, in developing the record for the Bipartisan Campaign Fund Reform Act by people who were involved in the process of selling access for money, of the influence of money. There have been prosecutions for acceptance of campaign contributions in exchange for favors. That is very different than here. We're not talking about an appearance of fraud here. There is no underlying actual fraud that anybody can point to that a voter ID would prevent. And so I think that, if we want to talk about flip-flopping, I mean, I think that the allegations can be made in both directions. On the one hand, the opponents of campaign finance reform strenuously argue that you must have, actual evidence of quid pro quo corruption before there's any legitimacy. But when it comes to voter fraud, they're perfectly happy to have a very differential approach to government. So
this isn't relevant.
No, I'm not going to that, but I want. Let me add one other thing, though, to the main question that I wanted to address here. First, again, let's stop saying there's no evidence of this fraud, right? Again, go read Elizabeth Holtzman in the New York Times. Okay, there's evidence of the fraud, but let's. I think the first question was, what would be the impact of this decision? And part of the impact will be, as I think Deborah said, how broadly the court decides the case, what kind of language the court uses. I think in this case, the plaintiffs have probably made a very unwise decision in appealing the case and probably in bringing the cases in the first place on such a thin record, because this is exactly the kind of case where you get bad opinions because we don't really know very much. And that's why I would urge the court to take a restrained approach that would leave the Indiana law intact as it stands and reserve the opportunity to revisit this issue if it ever turns out that plaintiffs can bring a case. And I think that would be a wise approach for a court to take, a minimalist approach.